I experimented this year, it comes up naturally. I just started doing it.
And if you're thinking about that as a microcosm for everything else, the Dollar General represents the school organization, and then you've got conversation about how that person is not good for you. So what if all of this picture, that thing that grows freely is what some of the most nutritious stuff that's that stuff coming from. I know.
They just passed that law to say you can now ship chicken to China, sell it here out country of origin. That's the other law that just passed. More country of origin on each packaging.
Thank you for getting that up on the screen. Thank you for getting that up on the screen.
Every employee has it on every business. You're going to need it. Oh, we're good talk.
The Planning Commission is back in session after a break. And at this time, the appellant will have time for a short rebuttal or information.
Thank you. Brian Momsen again for the appellants, Alex and Anthony Chihata. I thank all the members of the public for coming here and expressing their opinions on this. I really wanted to address the key legal issue here, which is what discretion you have to ask for environmental review and further study of this project. And what I didn't hear from either the Dollar General's attorney or the staff was pointing to that 2009 EIR and telling the public how this type of project for Redwood Valley was ever studied. Still has not occurred that has been pointed out. The counsel for the Dollar General mentioned that she questioned the language in one of my letters where I mentioned this project was of a pretty great magnitude, especially for this little town. And I think she said, well, a 9,100 square foot store is comparable to a CVS. It's not that big of a deal. I wonder if she's ever been to Redwood Valley. A 9,100 square foot CVS would be a pretty big deal for Redwood Valley. And that's my point. This was never studied. And if it wasn't studied, you have authority under the Day case that I cited to order environmental review, which is all we're asking for at this point. My clients support the free market. They're business people themselves. And they're not saying favor one business over another, which I think was Mr. Little's concern. They are saying that the law should be followed, and if an environmental impact of a project such as this was never studied in the first place, which it wasn't, it should be studied now. And I would point out that even the Davis case that County Council cited does allow for studying the possible environmental impacts of blight. We're not necessarily saying favor one business over another, but if it's a situation like this where very little businesses that can't price something as low as a big national chain are going to be put out of business, that is the legitimate impact that can be studied. And the Joshua Tree, San Bernardino County, the judge did order that. And Kelseyville, that was one of their grounds for denying the application. So I can see where one might look and say, well, you can't favor this business even if it's a little guy against a big guy, but you can study environmental impact like the possibility of urban decay or blight, which is all we're asking for at this point is the study. I did not hear much response at all to my arguments concerning the general plan, which again trumps the zoning. There are provisions that I've outlined in my letters, and I don't have time to go through them all now, but there was architectural theme, there was smart growth, there was promoting good, well-paying jobs. All these are the general plan, either for the whole county or specific to Redwood Valley. And those give you discretion. If you feel that this project does not match the general plan, you can order further study or even deny the application on that basis. So the owner of the property mentioned that this property used to be owned by Jim Jones, so I'm going to use a little analogy that you don't drink the Kool-Aid that you have no discretion. I hesitated to do that, but in any event, you do have discretion here. I've given you several legal reasons why we ask that you step up and be leaders, not followers, and be proactive about this, and again, err on the side of environmental review and public participation. Thank you.
Yes, Mr. Momsen? Mr. Momsen,
sorry.
we have a question for you.
You know, you stated, you know, the purpose of the protest and that is not, you know, competitiveness of business, but in reality it is. I mean, and I understand that, and I respect the market, the existing market, and, you know, the risk to their business, and if it was my market, you know, I would certainly pursue whatever course I thought was available to me to protect my market share. But you know, I personally don't feel that it's appropriate to use CEQA as an economic tool, and I think that this is somewhat the way it's doing it. And like I said, I respect the market owners, and I would probably be in the same position they are in terms of it. But the county council, and I appreciate the fact that you didn't have access to his arguments, and so you weren't willing to, or you weren't able to respond to those point by point. But in each of the cases that he pointed out, there were discretionary, it appeared to me, as I heard him, that there were discretionary permits as a part of the application. Although there may have been a ministerial permit, there was actually attached to it at one point or another in the process a discretionary permit. And in the Glendale case, the Day case, I guess as you referred to it, there was in fact a grading permit, and that the bulk of that decision was based on, as I understand it, on the grading permit. And that in CEQA, there's a specific exemption for building permits, as noted by the attorney, but there is no specific CEQA exemption for a grading permit. And certainly a large grading project like a freeway or whatever, I can see the reasoning why there would not be a specific exemption for something as major as a grading permit. The problem I'm having is that, I mean, as I've read through your arguments, and I've read through county councils, what the county's presented, it's a ministerial permit, and I don't know where the threshold is in terms of your argument, where all of a sudden county staff says, I've reached this threshold. There's no clear dividing line presented by you or what I've heard that says once you cross this line, all of a sudden, then we should subject this project to CEQA. If, say, Starbucks wanted to put one of their little Starbucks stores over there where you had a lot of traffic and you had certainly probably comparable amount of water use, would that trigger CEQA? I mean, would all of a sudden, based on your argument, would that also require a CEQA review? Let's say the owners of the Long Valley Market in Laytonville decided that they wanted to put a market in Redwood Valley, offering the same sort of produce and products that the Redwood Valley Market. Would that all of a sudden trigger CEQA? Is it the size of the store? Is it the external the parts of the store that would trigger CEQA? I just don't see where we as a staff or we can say, based on the evidence presented, what's the trigger that says this is a CEQA project as opposed to a ministerial permit?
The trigger is whether there was any environmental review of a project, whatever, whether it be a Starbucks, the Long Valley Market, Dollar General, whether there was any meaningful environmental review at any point in
But it's a
time.
slippery slope, because if there's no clear defined definition here that staff can go to, anybody that doesn't want, I don't want a Starbucks because it's a corporation and all the money goes back to Seattle, and I don't want a Starbucks. So all of a sudden, the argument is made, well, now there needs to be a CEQA review because I don't like Starbucks. So
Well, there wouldn't have to be a CEQA review had the 2009 EIR studied something like Starbucks. And maybe it did, but no one's
So
pointed
you're
out.
saying that potentially a Starbucks would require a CEQA review?
Potentially. I mean,
So anything. So if I own a commercial piece of property, if we've gone through the general plan and people have indicated that the government is going off and making decisions, but we held a lot of hearings on the general plan. I know there were community hearings on the general plan. The public had a significant amount of opportunity to address the conditions in the general plan. The general plan was not done in a locked room behind closed doors. It was done in an open public hearing environment. Nobody came here and said, in Redwood Valley, these commercial properties we want rezoned to something else because we don't want any more commercial business. So the staff relies on that when they look at these projects that are brought forward and say, it was zoned commercial in the prior general plan, it's zoned commercial in this general plan, we're issuing the permit.
but out of those sessions did come the community-specific portions of the general plan I cited to, like a consistent
So is
architectural
there,
theme.
okay, so like the
growth,
design standards.
Yes.
Yeah, are there design standards for Redwood Valley?
Consistent architectural theme is what the general plan reads. And a neon bright 9,100 square foot building,
Well,
I would
you
argue
know,
isn't consistent with the rest of the town.
We can, I'm sure
Yeah.
people can argue what's consistent when you look at a community like Redwood Valley. I guess I appreciate that. I'm just saying it's difficult for me to identify this threshold that you're trying to call for that says that this project meets this standard that requires a CEQA review. I just haven't seen that.
It's difficult
Yeah.
because it's really difficult to navigate that 2009 general plan final EIR, which is on your website. I've looked at it, and it's hard to find the words Redwood Valley in it. Certainly the general plan itself mentions Redwood Valley. But that's been a struggle of mine as well, that I've asked several times, where was the study for something like this in this downtown? And all the answer is, well, it was studied and it's a C2 zoning. So it's this circular reasoning, chicken or the egg type of problem. And the day case, just real quick on that, the grading permit was considered to be a ministerial permit, and the point of the case was that if it's never been looked at and never studied, the reviewing body can order a study. So whether it be, I think the distinction between a building permit and a grading permit isn't as important, as both were considered ministerial, but the important point was that that particular issue of filling this canyon had never been looked at.
Other than CEQA gives a specific exemption for building permit. It does not give a specific exemption for grading permits.
Well, in the same book that the Dollar General's attorney practice guide for CEQA, that case is cited for building permit review as well. I mean, it's the never been looked at that's the important part. Is there any other questions?
No, thank you very much.
Thank you.
And at this time, the applicant will have brief moment also.
Thank you. Sabrina Teller again. Won't touch on all of the points, but just a couple of good ones that came out of your discussion, Commissioner Little. The time to consider whether the community wanted the continued or new designation of commercial for this area of Redwood Valley was in 2009. And that is either when it was designated for commercial, or it was a reiteration and renewal of the long-standing commercial designation. I don't know which is the case. But what's relevant here is what your county code says about development that is allowed by right. So once you have designated it as commercial development in the general plan, and it is zoned C2, and there is, I've heard no equivocation about the fact that this is a general retail use and also maybe a food and beverage retail use, and it's listed specifically in the C2 zone as allowed by right. So if a reviewing court is looking at, is this a strictly ministerial approval, or does it have any hints of discretion in it, the first place it looks to is, number one, the CEQA guidelines themselves, and as you've noted, there is an express exemption for building permits. But it would also consider the language of the county code itself. And that county code, which allows this type of development by right in this zone, makes it clear that the county intends this to be a strictly ministerial approval. And that is the end of the inquiry. Now, Mr. Momsen places a great deal of emphasis and weight and hope on the interpretation of the Day case. But in the 40 years since that case has been published, there have been reams of other cases on ministerial and discretionary approvals and what is a ministerial approval. And there are no other similar circumstances where a court has said, you know what, forget what the county code says about allowed by right, and forget how the county interprets a ministerial approval that is clearly stated to be such in its county code. We're going to require you to open up CEQA anyway. That has simply not happened, and for good reason, because there is a level of certainty that is expected when you define an approval as a ministerial approval, and that is unquestionably what we have here. And without being too blunt about it, it does tie your hands in the kinds of factors that you can consider in whether to grant or deny the appeal. And here you are limited to looking at whether it meets the fixed standards and objective standards in the county code, and not whether everybody thinks it's a good idea or whether Dollar General is a good corporate citizen. I think, if we're going down that road, it is at least worth noting that the unstated benefits that you haven't heard about yet are the sales tax revenue and the property tax revenue that would come from developing a currently vacant parcel. So if we're putting it on a scale, there's that to consider. Lastly, the property owner wanted me to note, as a point of clarification, Jim Jones did not own this property, he owned the property to the north, so there is no Kool-Aid being drunk on this property.
Thank you. Okay, at this time then we'll go back to staff. Would you like to begin with comments, or would you want questions from us?
At your pleasure. I'm prepared to comment, but if there are immediate questions that you'd like us to respond to, we're available.
Well, I'm very interested in the Redwood Valley plan that was shown to us today. And do you know anything about it?
I can speak to that. In 2004, the board did, by resolution, authorize a work group, if you will, and a series of workshops were held to look at community development issues. And while there's no document or plan that resulted from it, there are minutes of meetings that were taken and are available online. When the 2009 general plan was adopted, it included community-specific policies. And I'm going to make a little bit of a leap of faith, but I do believe the result of those community meetings in Redwood Valley influenced the policies in this Redwood Valley community-specific policies section. And we put those up on the board as they're printed out. in the general plan, and a number of points that were raised by Mr. Mumson can be addressed here. And so I can proceed with that if you wish.
We'll see if any.
So in that regard, I believe the efforts in 2004 resulted in an expression of community priority and perspective in this section of the general plan.
Yeah, most of us that are now on the commission were on the commission at the time of the general plan update. And I'm pretty sure that each of the community areas that is specially mentioned in the general plan identified, there were planning meetings held in those communities prior, of course, to 2009. So I'm thinking that that may have been the one, but at some point it would be interesting to see those notes. I guess I can check it online.
Yeah, well, we do have it here, and I would like, if I may, take the opportunity just to address some of the matters that were raised that are asserted should bear upon this particular project and should be tools in which the commission can use to help either shape this project or deny this appeal, deny the project, approve the appeal. The first is, I just want to call to your attention, is that it very clearly states in goal number CPRV1 that this area where Dollar General is proposed, where it was designated or identified, is where new and existing businesses, commercial uses, would be directed and maintained. So at that time, 2009, it was very clear that this area should have the zoning that it had and should continue. And then also while not spoken of directly, it is mentioned in the correspondence regarding smart growth. Policy CPRV1 is here really as not as a dictate, but rather as an idea that is supported, that smart growth is a kind of planning technique or embodies planning principles that should be considered here. Now, smart growth is a host of principles and policies, and I won't pretend to be able to list those, but many of them are all about compact, community-serving growth that is efficient with resource use and doesn't result in sprawl, the loss of ag land, promotes local businesses. It's looks to these types of commercial centers as a kind of opportunity where you can bring together a variety of uses and activities and have them be synergistic or work off of one another. So inherently, I believe the compact cluster of commercial zoning that's here today supports that kind of smart growth, and directing commercial development as of right development that is identified as consistent with the zoning and the general plan land use classification is an incentive. Property owners can rely on that zoning to know these type of uses are permitted and they can come to that location and they will fit. And that's a judgment call that was made at the time the zoning ordinance was amended. It said in these type of districts, these uses inherently fit. And there are development standards to make sure they don't crowd each other out and so forth, provide parking and such. But inherently, they are the type of activities that are compatible with one another as compared to more intense uses that might inherently bring in more activity that could result in neighborhood conflicts or land use conflicts, noise, traffic, odor, those types of things. That's where a discretionary permit or review is needed, and that's how we use the use permit. And the zoning ordinance will actually specify those uses that are conditional uses where a use permit's required. General retail in this situation is a permitted use. It is seen to be a fitting use and not a use that would be in conflict with the intent of that zoning. So in that regard, this is smart. There are a lot of other concepts associated with smart growth that I won't address, and that we can't address through our zoning code, the way it's structured. The issue regarding promote economic infill opportunities by supporting infill and improve the aesthetic character of the downtown core. Policy CPRV3 has this statement, and then it's followed with some action items. And again, it's really important to look at what these action items say. It says, consider redeveloping commercial building facades on buildings located on these roads. That is not a shall, that is a consider. Likewise, the next action item, which has two parts to it, two different strategies regarding improving the aesthetics of the area. Those say improve the aesthetics in this area, but it doesn't. And then it outlines two potential strategies. One of which is that we should establish a consistent architectural theme compatible with the character of the valley. Everybody would agree that's a good idea. That's a good strategy. What we don't have is a tool to implement that strategy. In this case, the county has not adopted a design guideline that can be I'll use the word imposed, but applied here. And a design guideline could take effect on a permitted use, and it could take effect on a discretionary use. But we don't have that tool, and that might be one of the remedies that could be pursued with the community, with the Board of Supervisors, is to talk about how can future development in this location better implement or fulfill these goals, and would it be appropriate to have design guidelines, and what do those design guidelines do? Another strategy is landscape screening, and while again it's not this one talks about a specific location within town, landscape screening around the substation southeast of the downtown. Probably that's a good idea for any development, that landscape be considered as a way of helping to integrate the building mass with the existing setting. Furthermore, policy CPRV5 talks about the county encourages redevelopment of the northwest corner of East Road and School Way. One second. So that goes to the other direction. There's actually there's one policy that talks specifically about on East Road, south of School Road.
It's one of the first policies.
Yeah, let me find this. Oh, the first policy that I started this with was to look to commercial development south of Schoolway. Okay, so let me get back on my train of thought here. So finally, the issue regarding parking. That policy is written with a very kind of prescriptive type language, but it's a policy, and it says parking to be relocated off the East Street frontage to improve aesthetics. That's written very much like a zoning code requirement, but we don't get to apply that here because we don't get to reach into the general plan and condition a ministerial building permit with a general plan statement. We get to make sure that the project within that C2 zoning complies with the development standards, we get to look at whether that new development in the C2 zoning complies with the parking requirements. We don't get to look at parking lot design layout unless it's specified within the zoning code. So this is an important chapter for the community, and I think it states a lot of potentially, well, certainly in 2009, the intent of the community as it was expressed through the general plan process. Attitudes, values change over time. An event like we're dealing with today can certainly stimulate renewed interest and call into question the appropriateness or the completeness of these policies, and could trigger the need for additional planning review. And that process is a very community inclusive process. If we just do the minimum as required by state law for planning, we hold public hearings where the public get to comment. You will have the matter before you, and then it'll go to the Board of Supervisors for their consideration. Our practice is to go out to the community with workshops and be able to talk about what are the competing interests or the goals in town, and try to reconcile those before they come to you, the Planning Commission. So going back to this idea that we have this potential remedy that comes out of this meeting, I think the remedy is to elevate this discussion and bring it to the board and talk about a community need that might be fulfilled through a community planning program. So that sort of concludes my overarching tie together of how the general plan policies are in play here, and they're really in play through the zoning code, the way it's expressed. And for a permitted use such as this, the zoning code provides predictability for the property owner, for the community, when you have permitted development, and it provides opportunity for community engagement when you have discretionary review on projects that ordinarily would be potentially creating land use compatibility questions.
But if, for example, we have a community character policy in our general plan that says the community action plan could be developed in the community areas, and then they would be the preferred plan. If that had been done, and the community action plan was more restrictive with zoning codes and was in place, then the community there would be guidelines to follow. They could the community bike lanes, bike parking apparatuses, landscaping, lighting, all of those things could be addressed if that had happened.
Right, but what's important to remember is the general plan by itself, while it indicates where we want to go, doesn't get us there unless we have implementing tools.
Right.
And so the general plan includes implementation, it has an implementation program, and it talks about a variety of things, including implementing these ideas as well as all the other ideas in the general plan. So while there may be a specific call for community design guidelines, the guidelines would have to be adopted, and that in and of itself would be a very public process and would be the result of community input, Planning Commission review and recommendation to the board, who would ultimately act on it. But without that implementation tool, we can't get there on a ministerial permit, on a building permit for a permitted use. So that, unless there's other specific question, there's one, I think, related idea with regard to the validity of this current zoning in context of what the general plan says. While we can identify action items that haven't been implemented, the zoning code identifies zoning uses or use types and development standards that have been found consistent with the general plan. So Graham pointed out the two maps that showed the general plan land use classification and then the zoning. The zoning must follow the general plan, and in this case it does. The uses that are expressed within the zoning code are also similar to and the same as the uses that are described associated with the general plan designation. So there's harmony, there's consistency there. And then you look at the intent of the general plan land use designation and the intent of the zoning code, and those tie together as well. So in that situation where you have a permitted use, again, we're seeking to establish a framework where property owners, communities, speculators, out-of-town property developers, in-town developers know what the game rules are and can make an investment, have an expectation of an outcome with some predictability. And so for that reason, these permitted uses are given that mantle of acceptance or encouragement, if you will, to allow them to develop without the uncertainties and risks associated with a discretionary permit and also CEQA review. I do want to just confirm that the Kelseyville Dollar General store was subject to a major use permit, so in that context, that community discussion was all about its appropriateness. And that community made the determination in its general plan and its zoning code that a general retail store such as Dollar General is subject to discretionary review. That's not the case in this county. Maybe I should talk a little bit about CEQA review in the 2009 general plan. So the general plan is the fundamental document that guides development in the county, not only land use, but resource development, housing, I mean, a wide variety of issues, and it is broad-reaching and encompassing, and it's a process that is, by virtue of its breadth and its geographic area, has to be general. It has to set guidelines. It has to be the framework under which specific projects are reviewed or analyzed. And the general plan is evaluated by CEQA as a program EIR, meaning it's kind of like, I don't know, maybe it's a good analogy, a recipe. You know, we're looking at the recipe for a meal, and we're making sure the internal parts work and no one's getting poisoned. But it may be that, and we can approve it, but when somebody comes to actually build something or cook the meal, we want to make sure they follow the rules and have the spices correct. And so this program EIR is making sure the menu's good, that the recipe's good. And then the project EIRs are there to make sure the right ingredients were put in, making sure it actually came off correctly. So in this case, it looked at this general county-wide circumstance and found that development of intensity, the term has been used, worst case scenario. It's really most intensive land use development scenario was proposed and evaluated. And there were a number of findings made to adopt the general plan that there could be traffic impacts, there could be water impacts, there could be air quality impacts. But overall, the plan's outcome was beneficial to the community and was adopted with a variety of mitigation measures, land use controls, for instance. For instance, some land uses were required to be conditional uses so that when they came forward with a specific project in a specific zoning district that was a use that's permitted, a use permit, we would have the opportunity to conduct a detailed review, focused review, a project EIR on the specific development, where we could reconcile what is actually going to happen with the project. In this case, I don't have the list of conditional uses that are allowable within the C2, but
Allowable?
excuse me, a conditional use.
Major use impacts, emergency shelters, things of that nature.
Yeah, there an emergency shelter or I always wrote a nuclear power plant is going to require a use permit. We're going to look at that very carefully under the use permit and do the environmental review and evaluate the effects of that type of use on the community, and we'll be able to condition it. We'll be able to reach into the general plan and use policies there to support or deny a particular use because of its potential conflict with the community character and health, safety, and welfare. So, yeah. So the program EIR was conducted. It considered this project. This is a permitted use. It has been fully evaluated. A project EIR is not appropriate, nor can we require it in this instance.
Okay, yes, ma'am, please.
I'll give this one more chance. Deputy County Counsel Matt Kudrowski. I wanted to speak to Mr. Little's comment on discretionary versus ministerial and that threshold. And I'm going to go back to the Day case because it actually has a discussion of this in terms of what was found to be a discretionary grading permit in that case. It looks at items where there's things that are without fixed standards or objective measurements that need actual judgment on the part of the planner for approval. So in that case, there were the ability to impose certain regulations on a grading permit. And so once they have that authority, that's a discretionary permit. So that was one of the reasons why I think Day is distinguishable, because it had discretionary elements as part of that review.
Okay. Graham, anything more from you at this time?
Is that better? There we go. Sorry. The commission should actually have a list of the permitted and uses that require a minor and a major use permit in the package. In the zoning clearance letter, it should be in there for you.
Right, we do. And there are quite a few.
One more note. There were no signs included on the building permit here. And I've heard something about neon signs, and a few of the letters addressing that also said something about neon signs and neon glowing. Our signage policy, again, no permits for signs have been applied for. You saw one on the elevation. That was strictly as a visual idea of what it would look like. The building permit explicitly said that there'd be a separate application for the signage. Neon signs would most likely not be approved in our sign code, chapter 20, section 20184.025C. Signs that cannot be constructed so that, or signs must be constructed so that no light bulb, tube, filament, or similar source of illumination is visible. And essentially that would be a neon sign. So there is no neon signs that would be on the store. I just want to make that clear.
Thank you. Well, commissioners, are there questions you have of staff or want to make comments?
I have one, Andy. I'm sorry. Towards the end there, you said something about bring to the supervisors and community meeting, and I was a little unclear as to what you were referring to there. Could you explain that a little bit better?
Only that if the community feels the current land use regulation, the zoning ordinance, doesn't provide the tools necessary to manage and guide growth in their town in this area, that we need to develop rules that will do so. It could be design guidelines, zoning ordinance amendments, zoning map amendments, general plan policy amendments, but those are separate and apart and would come from the board directing the PBS to implement or to bring to them such plans or such tools. And there would involve, and community meetings would be a part of that process.
So that's more or less after our decision today.
Yes.
That doesn't give us a direction on this project.
No, it's not direction for this project. Today's appeal is narrowly limited to the zoning clearance and whether or not it was done correctly.
Comments, anyone? Well, I'll start out with one. I think that staff's position is clear and probably correct in terms of following good planning practices. But I have such a hard time with this, and I think I want to come at it at a different angle, which is not so much from CEQA, but from this community action plan. And that until that is done, I mean, it has been a long time since our general plan was approved. We still haven't done the accompanying zoning code changes. So until, now that Redwood Valley community is awake and aware, I just think that until that's done for them, that no commercial building permit should be approved. That's all I can say. I don't know that that's right, and it would probably never hold up in court, but I want something for the board to look at that's a little different, and if that's a de facto moratorium, so be it. That's my thoughts at the moment. But, and we don't need to comment in the public. It's really pretty serious deliberation, so.
I agree.
I don't agree. I think that the staff has analyzed this properly, and I think one of the things that bothers me is this allegation that the environmental impact report for the general plan may be deficient, and that would be the basis for applying an EIR on this particular project. And I'm not in any kind of a position to agree or admit that the EIR is deficient. And if that claim is really serious, I think it should come forward in some other kind of form. I don't think that it's appropriate to be analyzing that particular EIR in this particular hearing. I think staff is focused very narrowly on this particular issue. Is it a ministerial act? Yes, it is. And the building permit should be approved, and I support what the findings were.
Very good. Thank you, Roger. That it? Well, are we ready for a motion? Do we have a comment?
Excuse me, Madam Chair. Doug County Council. I just want to remind the Planning Commission exactly what they're here for. It was stated very well. It is a very narrow issue what you're voting on. I know there are a lot of emotions involved in this. I know there are a lot of emotions involved in this. I know that there are other issues people want you to consider, but what is before you is a very narrow issue as outlined by the planning department. And that is what you should be voting on, and that's the only thing you should be considering. Thank you.
You're right. I may not have officially closed the public hearing, so I want to be sure that we know that that is happened. We are closed for the public input. And I think we might be ready for a motion, if we have one.
Well, first of all, I'd like to state a few concerns that I have, and I definitely have a concern about water. But I think it's been very clear, according to county council, those are not things we can address. I also have a concern based on the comments of many people in Redwood Valley that are not, presumably not going to support the Dollar General. And if that does happen, I am concerned about a blighted building. You know, perhaps another business could come in and fulfill that location, but that's just a concern I have. I personally really would like more study on this for the reasons of water and blight, I guess. But I also have concerns about allowed by right based on zoning and the general plan. And from what we're hearing, at least what I'm hearing as part of the planning commission, is our hands are really tied. Unfortunately, a lot of these things that should have been addressed during the general plan were not. The zoning's correct. The only thing I can see that we can do is deny the appeal. Not that I like to, but legally that's all I can see to do. So I am going to make a motion to deny the administrative appeal, AA 2015-0002, finding that the building permit BU 20150104 zoning clearance is granted based on the staff's determination of the 4 items listed.
And is there a second?
I'll say.
We have a second. And we'll have a roll call vote.
Commissioner Hall?
No.
Commissioner Kruger?
Yes.
Commissioner Little?
Yes.
Commissioner Ogle?
Yes.
Chair Warner?
No.
Commissioner Holtkamp?
Okay. The appeal has been denied. And
Do you want to, I think probably it's appropriate to state the procedure for an appeal to the board
yes.
within 10 calendar days of this action. If no appeal is filed by that time by the county, to the county clerk, not county clerk, but the clerk of the board, this decision stands.
So it's a 10-day period from tomorrow?
Yes, from tomorrow.
From tomorrow.
We'll,
Okay, and thank you for that information. That's good. Okay, I think that concludes it then. Thank you very much.
No, I voted yes.